G'day, Clayton here from XY Advisor. Myself and Ray Jaramis, multiple award-winning Ray Jaramis, interviewed Donal Griffin, our resident legal expert. He's actually got a course on xyadvisor.com. Go check that out now. Donal's really knowledgeable, really knowledgeable in this space, especially on trusts. So we spend quite a fair bit of time sort of talking about the complexities there and about deeds and about case studies and a bunch of stuff on how to use them best as a financial planner and how to really sort of start impressing your clients by getting a little bit of knowledge and building up over time. So hopefully you enjoy. This episode is proudly sponsored by Netwealth. Launching nearly 20 years ago, this ASX-listed company is ranked number one for overall platform functionality and user satisfaction by investment trends for the past 3 years. As the financial advice landscape changes, it's important now more than ever to embrace new technology and enhance the way you do business. With this change comes your chance to innovate, explore new perspectives, and realize new efficiencies. Netwealth is here to support you on this journey by providing you market-leading technology, excellent customer support, and expertise to help you innovate in your business. Visit the Netwealth website to learn more and get the PDS which clients should read before making a decision. Products issued by Netwealth Investments Limited. Does a binding financial agreement help at all for anyone?
Wow, straight into the hard questions. I thought this was a chit-chat. Look,
Clay may or may not be getting married next month.
and it's my fiance asking me.
So this question is loaded. Okay, there'll at least be an audience of one for the answer of this.
Yeah.
All right. Well, just between us.
Yes.
It depends if you have the money or whether you're the person with the money or not. They've dropped the word binding from binding financial agreement. So now they're just called financial agreements, which would give you the sense that maybe they're not 100% binding anymore. They're definitely persuasive and helpful, and they can be binding. What happens is there was a High Court case late last year where one was knocked down and found to be not enforceable, and that was because of the circumstances rather than the document.
No way, the circumstances of the breakup.
Circumstances of the getting the document signed, i.e. Undue influence. So if you're just too cute about it and just kind of slide it across the table and say, look, just please sign here, it'll all be fine, and there's no genuine negotiation, and the other person can always say later on, well, I felt like either I signed it or the marriage was off. It makes it easy for a lawyer later on to say, well, it sounds like there was undue influence at play.
Because the circumstances of the breakup don't come into judgment at all, do they?
No, well, it's a no-fault system in Australia, which means that if one person's been playing away or being obnoxious in one way or the other, it shouldn't affect things. But within the agreement, it could say, if the property settlement and divorce is initiated by one party rather than another, the consequences are ABC.
Oh, right.
So
so you can actually put fault in a financial agreement.
Essentially, you can contract contract whatever you want.
Really, and the family court is willing to look at it quite persuasively.
Yeah, look. Where they're hard to hold on to is where circumstances have changed dramatically, and the most obvious one of those is where you've got two youngish people earning good money, they agree some kind of split, and then fast forward 15 years, one of those people has maybe taken time out of the workforce to look after kids.
Yeah.
And the other maybe has gone on to create a business or draw a very good salary, and maybe the other one who's been left behind, maybe that partner can't get back into the workforce at the same level.
Absolutely.
So the court ultimately has a jurisdiction to come up with a decision that's just and equitable. So, it will take all factors into account. So we don't want to act in scenarios where people say, look, I've got all this money, he or she has nothing, it needs to stay that way.
Yeah.
What we do say to people is, look, particularly if they've got kids from a previous relationship, we can say, look, family law is a nightmare. You've got a previous relationship, you've probably got some experience about this. Next time round, you might want to say, well, look, our priority is our own particular kids. Let's save ourselves 3 years of legal fees and therapy and the recovery of it, and just agree what we think's fair. That can work very well.
So this is the stuff that keeps you busy Monday to Friday?
Yeah, all sorts of things. We do boring stuff like tax rulings, and then we get random things like people crashing their yachts on the harbour, or having hurt somebody, or criminal issues. People looking at trust deeds, and for the first time, tweaking them to helping a couple with an adoption process, where you normally don't have lawyers, and adoption agencies just take control of it, and they're saying, well, what are our rights? And I didn't know the answer to that, but I found out the answer. They were very pleased. They said, oh, look, they've been asking around, and I was literally the only person who was able to answer their question. So there's weird arse kind of areas. But look, our position is to be the trusted legal advisor to families who are doing interesting things, either sometimes to each other, hopefully with each other. So yeah, every week is a little bit different.
Something really interesting on trust deeds is the digital signature laws don't apply. Right, and so I think in the legislation it can be written on paper or leather parchment or some crazy.
I love those little legacy elements of our law,
and yet an uncomfortably high portion of SMSFs have their trust deeds digital.
Right. Okay. So
now you're left in a situation where your trust deed of your SMSF is invalid. So that's an uncomfortable.
Really?
Yes. No. I've super looked into this. Super
looked into.
Yeah, you like that?
Yeah.
Has anything like that come across your desk?
I haven't seen that one. Look, there's a very famous trust law case called Kennan and Spry, where Dr. Spry was and is an expert in trust law, and one of the positions he took in a very high profile case was that he had an oral trust. So really legally you could have a trust that is not in writing. Now it doesn't help you if you're trying to enforce the provisions of that, and it asks more questions than it answers, and it didn't really work out for him overall at the end of those cases, which ended up in some criminal cases. So, look, you do these things for some certainty. We say, the online things are great for certain things, but, will the provider of those online services be around? Will they stand over their documents? So sometimes old-fashioned schlepping into somebody's office, and, taking out the pen, sometimes that's probably better from an advisor's point of view to have somebody relationship with somebody like that. I would be, and of course it serves me to say that, but that's kind of our pitch. That's our positioning, rather than producing or enabling the production of thousands of documents all around the country where there's no kind of real personal connection. But those guys, there's a few providers, and I'm sure they've got some good answers for those kind of questions and service.
The protection thing's kind of interesting because that falls into a space that we sort of touch quite a lot as financial advisors, but I just wonder, and I would suspect that all too often we would see trusts set up where you've got the trustees and the beneficiaries and the settlers and the appointers being the same people the whole way through, which I would suggest kind of destroys the reason why trust exists, because we're seeing more and more that the courts are cutting through that entity, aren't they?
Piercing the veil.
That's right. Yeah. Good expression. Yeah.
Yeah,
we are seeing a lot of that. And look, 95% of cases, that's a figure I've pulled out of my back pocket. I'd say it's probably higher. Have mum and dad, or mum or dad, or whoever is the client, in the key role as appointer, controlling the trustee, and as the primary beneficiary. And that's all fine, or at least it was fine. But if you, and I appreciate the context of these trusts, people, they set them up very quickly. They don't want to spend much money. There's usually a property or something that's far more interesting being acquired, and this is just paperwork. But in the cold light of day, if you, and I do, sit with them and say, right, well, you understand that this is the person who's controlling this, and ultimately we find that the trust is not very strong for asset protection purposes. The money's come in, been put into the trust by that mum or dad as well. So, it's very easy to pierce the corporate veil, as you say, Clayton. The other thing we're seeing is second wives or second husbands being horrified to see that within the beneficiaries, the ex-spouse is still in there.
Whoa.
And often they're, I was talking to an accountant today about the ex-wife is a co-appointor.
Right.
What the hell?
Yeah. So, on a sunny day when everything's good, people, decisions are made and then just totally forgotten about. So it's worth getting those roles right. If you're going to put somebody in as an appointor who's not you might ask them to sign a resignation letter at the same time.
And what is an appointor for those that are kind of looking at this space?
At home.
Yeah.
Sure. So an appointor is the person usually who can appoint and remove the trustee. So they're God, if you like, in terms of they control the trust. Sometimes in the trust deed, it will say that certain decisions have to be made with their consent. So, their role may be beyond just appointing and removing the trustee. It might be a veto over changing the terms of the trust or making certain types of distributions. So whoever you put in there, you need to have an exit plan. And we're seeing, so if I see a client and they say, oh, okay, well, what now? I mean, I'm the appointor. I would say, well, if your kids are over 18, you might want to start appointing them and truly make a family trust an intergenerational structure.
Okay, so the children as the appointor?
Yeah.
Okay.
Yep. And that's helpful for everybody because then they can say for, a long period of time, there's been multiple decision makers in relation to this.
Can the appointor not look at the beneficiary as well? Or are they kind of fixed? Because I imagine if you're a beneficiary of a trust and a claim's been made against you, then that's kind of the time where you might want to remove yourself from that entity?
Yeah, the appointor doesn't usually have a role in terms of beneficiary directly. They do indirectly because usually the trust deed will say the trustee can expand or reduce the class of beneficiaries.
Right, so there's a link.
Yeah. So, but look, it's a bit late when there's trouble to be removing beneficiaries. It's better that it be a clean skin structure. So sometimes with people, I just say, well, look, you can amend it, or you might want to have a new structure and put cash into the new structure. So from day one, the cash has come from your wife rather than from you, which is really reasonably easy to facilitate. And the wife, for instance, was the appointor. So at least, from day one, that structure hopefully is stronger than the previous one. I mean, and once you start changing things, well then there's a line in the sand and you can, follow the history to see, well, who changed it. So.
So, I mean, it feels like a bit, not a minefield, but it feels like something that I think advisors should probably look at. But if you get it wrong, you're putting yourself at a bit of risk and your clients, right? So would you kind of be of the mindset that advisors should be looking at this sort of stuff and spending more time, or really kind of maybe taking a step back and saying, no, we do the behavioural stuff, the cash flow, the investments, and the entity is really pushed away to the accountant or the lawyer?
Look, the advisors that I see who have the strongest practices tend to look at this stuff because it gives them more things to talk about. And especially if you're stepping away from the investments, well, then it's, well, what else am I going to talk about? And really we see ourselves as part of the financial services community, really. But it's about goals, and then it's about strategies. And you can bet your backside that not many of your competition are doing it. And once you've done it a few times, you look at a trust, for you to say to a potential client or an existing client, oh, I've looked at page 32 of your trust deed and I'm telling you stuff you don't know, they're usually reasonably impressed. I think it shows an attention to detail. You make it clear you're not giving legal advice. But once you've done it a few times, then you're able to say, look, in my previous experience is you being the appointer has certain consequences. I believe it can be fixed. I can believe it can be changed. So it's up to you. I mean, if you're not going to go there, I would advocate that you clearly limit your scope and you make it very clear in your contractual documents. We will not be looking at legal documents, and we don't give legal advice and all of that. But if you do want to play in the area, it's a real differentiator between you and maybe somebody else who's competing for the business. And also, it's a way of removing a problematic accountant or building your relationship with the accountant. So, for instance, you could say, listen, the accountant set this up. That's your opportunity to go to the accountant and say, look, I want to work with you on this, but I gather that that's not the most sophisticated structure. Do you want to now say to the client, or will we say to the client, that was then, this is now? Or you can use it as a way to say, look, that guy maybe isn't, he or she could have given you maybe a bit more sophisticated advice on this. I've got a guy who can do it, and off you go. Because as you know, sometimes, advisors competing or not in the same area, but an accountant can be a problem, for instance.
Yeah. Testamentary trusts. I've worked in personal finance for about 10 years. I've never come across one.
Holy moly!
Like as in one that was distributing funds.
That was active.
Yeah, I've never come across it.
Donald's done one for us.
Really? Are you dead?
No.
I actually...
VR's amazing.
This explains a lot.
Yeah. Donald's all over this.
Yeah, look, we love them. They are good structures. There's great tax efficiencies. Once people see, they really... They thank the person who has set it up, essentially, because you can look the beneficiaries in the eye and say, this is actually the most tax efficient structure you can have. This is like, I guess Super's very tax efficient.
Yeah.
But this is like a super fund that you can access when you're 18.
Yeah, that's great.
So, and grandparents like the idea, because essentially very quickly you're starting to distribute money to grandchildren. And then you're saying, right, well, the money's, what are you going to use it for? Maybe it's school fees, lifestyle. So, yeah, it's a beautiful thing once it starts distributing money. There's a few mistakes people make in relation to it. Sometimes they think, it's got excessive asset protection. If the structure's not right, it might not be as strong as it could be. But, we say to people, look, you can have your cake and eat it. For example, it's the largest lump sum most people are going to get is an inheritance. Using an example of, say, 500 grand in a testamentary trust, you either invest it and have tax advantages, or the other more common one is, look, well, I've got a mortgage of 500 grand. Shouldn't I just pay off the mortgage? I know from my previous life that paying off non-deductible debt is a good idea. But if you've got a trust, testamentary trust, you can essentially borrow from your testamentary trust, pay off the bank. And if a trust is lending 500 grand, it's acting like a bank. So you'd basically just swap the mortgage to the CBA with a mortgage to the trust.
Mm-hmm.
So essentially the balance sheet of child is real estate, and they still have a mortgage. And at that time, they can even negotiate with their spouse and say, listen, mum and dad have left me this money. We can pay off the mortgage, but my advice from my advisors is that we do that as a loan. How does that sound? It'll be interest free. And at that stage, the child can negotiate something with the spouse to say, well, look, I'm prepared to use my entire inheritance to pay off this mortgage to the bank. But you've got to agree that you won't make any claim against it, because it's clearly set up for me and our children, And while you're, on good terms, you can enjoy living in a house where no interest is being paid. And we don't have that fear of interest rates going up, et cetera, et cetera. So it works pretty well.
That's it. I think that's exactly why my fiance wants that financial agreement.
In my experience, it's the grandparents really loving the facility or what that affords for the grandkids. It's often, and I think as people start to live a little older as well, they're especially a lot of my clients are still around at a time where their children are financially independent, and they're it's more the next step. So talking things like tax-free school fees and those sorts of things, because mine has access adult tax rates and all that sort of stuff.
Can you put unique terms within this testamentary trust, such as let's fast forward 50 years from now, we're all hanging out on the porch and we're all about to keel over, and we've all got a testamentary trust, but we've got a 21-year-old grandson, and we say, you need to clip over the shoulders or whatever, right? and you don't. I don't want to give you all this money. Can you have in the testamentary trust things like this particular person needs to go and do university, or can you put terms on it?
Yes. Well, look, people have tried, and they usually fail. In the olden days, it used to be linked to religion. So it would be, if you're practicing X and Y, you get the money. They used to sometimes have provisions like if you challenge the will, you get nothing. All of which the court have not been too sympathetic to, because they go, look, that's against public policy. And one was tested recently in a case called Mead, which was the $1 billion case in WA. Lang Hancock's business associate died, Mr. Wright died with about $1 billion, and he had a child out of wedlock, and he left $3 million in a trust for her. But from memory, he had provisions in the trust which said basically, you can have this money as long as you don't become a Buddhist. Don't. It gets worse. Marry a Muslim, and various other things, right? So you can write, so that's the old guy on the porch going, right, telling his lawyer, you write this down, and people with funny names, not to be involved.
Right.
So, anywho, the court found, we used the barrister who got her $25 million initially, and he was able to persuade the court that, look, that was against public policy. People can't do that.
Yeah, totally.
Now you can do it during your life. You can set up trusts and have whatever provisions you want in there. The way to essentially achieve the same result is to control who the decision makers are and leave them some wishes and their directions. And if they've got no skin in the game, they might be happy to carry out the dirty work of the person.
Just a memorandum of understanding.
Yeah, memorandum of wishes. Yeah. But essentially, if you put it in a will-style document, then they're able to challenge it on the basis that really the money's not really there for them. There's a risk that they might not get it as well. And why should they have to jump through these particular hoops in order to get it? So, look, you can create your own adventure in different ways. I mean, I've got a client who is an investment banker. He's got lots of money, and he went to private school in Sydney, and his brother's up on the coast somewhere, and he said, look, the kids would have to live with him, but I want them to go to the same school that I went to in Sydney. So how do we make this happen? And so he essentially set up a trust and blackmailed his brother, or at least he's going to reward him financially.
That's a better way of putting
it. If they do certain things. That's right.
Yeah.
So look, there's ways to achieve certain things.
Yeah. Now, a part of the reason why I've been pushing these controversial fringe topics is because you teach ethics at your son's primary school. So I thought that's quite an interesting. You're a lawyer and you're teaching ethics, and if I learned anything from my CFP subject 1, the ethics course, was that there is a deontology style of ethics, which is to do the right thing because it's the right thing to do, and then utilitarianism, the right thing to do for the most amount of people. So I've got to ask, mate, are you a deontologist or a utilitarian?
Is there only two options?
Oh, I'm sure there's more.
Oh no, I'm my own style. Yeah. I'm an a la carte ethicist. Look, my role is to follow the curriculum written by the St. James's Ethics Centre. So I'm not allowed to go in there. I've got my son here today who's quietly reading his Hitchhiker's Guide to the Galaxy book, which I'm very proud of. But no, look, it's a course that's written by the St. James's Ethics Centre. It's fantastic. It basically explains to kids that everything's not black and white, and it's been written by educationalists who understand, the different stages kids are at. And it starts off very simply with, analogies about cats and dogs and how they're different, and sometimes they get on well, sometimes they don't. Then it's moving on to respecting other people's opinions and people's rights and so on. And the beauty of it is they get to hear from each other rather than just a teacher. And the kids who are quieter, let's say, get to hear their opinions respected just as much as the kids who are maybe a bit more confident and more usually the ones getting questions right. And it's very subtle, but I recommend it. It's in public schools in New South Wales only, and very rewarding for those who are interested in who have kids, to teach your own child and see them in action in the zoo.
Yeah, my stepfather taught us our soccer team for a year. Then definitely throughout our whole history, that's probably the closest that we ever became, or the most time that we ever spent together. And it was kind of cool seeing how people respected him. So it wasn't just our relationship, it was me and my team, and collectively the respect for my stepdad. And that was really cool.
Yeah, I can imagine. No, it's very rewarding from the teacher's point of view, certainly. And the kids have a good laugh. It's more relaxed than a normal class. They sit around in a circle and get to poke fun at me. So I think my son enjoys mocking me. But anyway, we'll see.
So is it through hypotheticals, or what do they how do you teach kids about ethics?
Well, there's often there's a story. Recently, there was a story about messages, the Delphi Oracle, and
that's Spartan, right?
Yeah. So ancient Greece, and there was this person who essentially had made statements, and whether they were going to be true or not, and then. Basically we pointed out that by putting the comma in different places of a statement of 10 words, I can't remember exactly what it was, but it was something along the lines of, it was a bit like Yoda, go to battle you will and come back dead. But if you put the comma in different places, it had very different meanings. So that basically the subtext was, well, anybody who's telling you these kind of things is often being a little bit rubbery with the truth, and beware to take things at face value, and things are open to different meanings. A bit like a PDS or a prospectus, probably.
Speaking of which, you moonlighted as a financial planner for a little while. Is that right?
That's right. My therapist says I'm making good recovery. Keep taking the tablets. Yeah, I did. And look, I really enjoyed it. I learned an awful lot. I learned what a tough job it is. I did it during the GFC, which was pretty hairy, especially because I didn't know anything about investments and the markets were going crazy. And that was back in the day, really, when a lot of advisors were purely investment. I
could just
junkies.
imagine you holding the graph but it's upside down. Wow, look at what we've been doing lately. That's the wrong way. No,
I think I did do that. Yeah. But look, it was really good to get to understand the dynamic, how processes, the relationship, things that were very unlawyerly. I remember going for a job as a financial planner, and I thought I did a good interview, and the recruiter phoned me up afterwards and said, how do you think you went? And I was like, oh yeah, actually pretty good. What was the feedback from them? And she said, well, they thought you were a bit lawyerly, actually.
Okay.
And I was like, oh, I thought that was what they wanted. And she goes, no, really, you needed to bond with them and kind of win them over a little bit, rather than just go, I'm the oracle and I've got this great information, and if you pay me a fortune, I will release it to you.
Hire me, you will.
Yes.
Start instructing on them on where to put the comma.
Yeah. Close the door after you will, they said. So yeah, that was a very interesting experience for me, and so we bring a little bit of that into how we practice, and we want to know the big picture. And like I said earlier, really it's about the goal. So, I can assume that somebody wants one of my lovely documents, but actually their biggest concern might be to talk about a relationship problem or a business issue or something that you guys will talk to people about. So we're just a bit more careful. We try and find out who their advisors are, if they have any. If they don't have them, we say, you might want to get one. Particularly accountants, that's a really easy sell, for people who do their own tax returns. I go,
Do you see a lot of that?
A fair bit.
Yeah. Wow.
Especially people who used to be accountants.
Yeah.
It's a bit like lawyers kind of doing their own wills. They kind of do it. And I say, if you go to somebody, the fees are deductible, and they'll probably find something that, will
wash it away
and give you a bit more time. So sometimes people are control freaks and they just want to do it themselves. But look, we're believers in having a third party there to bounce ideas off. I've got a financial advisor myself, and he helped us. We bought a property recently, and he's talking to us about how quickly you pay it off. Mortgage brokers, funnily enough, don't do that. And, he knows what our goals are, and talking about maybe buying an office or something, and
do you
different
give him
ways
lots
of doing
of
it.
grief on the SOAs?
He
had a guilty laugh.
I'm trying to figure out whether he'll be listening to this or not. No, I'm a very good client and forgiving for commas being in the wrong place and full stops missing and so on.
Just not extra zeros with commas next.
No, we watch out for that. And I do ask him, how much do you get paid for this?
Good.
And I think I cancelled a trauma policy yesterday, which won't endear me to your audience.
You didn't even reduce the amount?
Well, I tried to cancel it, of course, and then the guy said, we can maybe reduce it to very little. We can't cancel it because there's a life component.
Yeah.
It got very tricky.
Yeah, kills stamp duty.
And my mate said, I said, how do I cancel it? He said, well, you can either phone up or we can do a statement of advice.
To cancel it.
Wow.
Yeah. Wow.
So, which I think was his subtle way of saying, please phone them, and you don't want me to do a bloody statement of advice.
That's ridiculous, isn't it?
It is.
Yeah. See, I never sold much insurance as an advisor. It wasn't really something that I enjoyed doing. It wasn't part of the job that I liked. But I'm actually a massive believer in it, and I have it. So for you to be 100% out of trauma, that's scary. Isn't that scary?
Well, the bloody cost was the scary thing, So maybe some of your listeners can phone in and tell me they've got a great deal.
Trauma quotes by the time you check Facebook.
30, what is it with quotes?
Yeah, there were. I mean, it was like a 200 grand cover, and I think it was going to cost me over $2,000. And I was thinking, I was looking at
1 in 100.
Yeah, exactly. I thought that's a bit cheeky. Give me another 0 or something. You know? Anyway, we'll see. Hopefully, I'll be self-insuring for those kind of things before too long. So
very good. Very good.
Well, mate, thank you very much for your time this afternoon.
Pleasure.
For those that are keen to maybe learn a little more, get in contact, what's your...
Beyond you having a course.
Of course,
on
sorry, my mistake.
on xyadvisor.com. So we just recently released a beta version, and you were one of our top 4 or 5 courses.
Founding teachers.
Absolutely. So beyond that accolade, where else can people find you?
Well, look, we're really pleased to do that course, and I think we in the course we try and make it easy for people and encourage them to get involved in this area, and hopefully there's some legal stuff, but also just some practical things about how to engage and make this part of your practice if you want it to be. You guys are emotionally intelligent enough to be able to sell yourselves and your services, so really a lot of it's actually small talk and just inquiring about people's families and comparing yourself with them and saying, look, I also have a growing family, or I have a business, or whatever. So yeah, looking forward to all of that. Look, we've got a website, legacylaw.com.au. We putting on some videos on that. We review all the cases, so we published an article just recently on a situation where a carer, a lady worth about $1 million, had a cleaner who became her carer, who became her friend, who ended up getting the entire estate. Yes, so that's of interest to people, particularly if their parents getting older, and maybe they've got maybe it's their brother or sister is the carer, or maybe it's a third party. So you just need to be careful out there. So yeah, we publish articles from time to time. We're on LinkedIn. Please link in with me.
How do you work with advisors?
Look, we really want to team with them and get them to. If they don't want to go to meetings, that's fine. But I always encourage them to come to the meetings. I make a big point that the fees are lower because the advisor's involved and information flow is happening smoothly and efficiently. But first point is, give us a call, tell us your scenario, the client scenario, and, we might even agree a fee on the phone, so that you can then go back to the client and say, listen, this guy will do it for X or Y. Because I understand it is hard. People don't want to just go and see a lawyer and expose themselves to the potential costs without having any idea. So we like to work with people like that. And then over a while, we do fixed fees so that, the advisors are able to say, look, this is what you get, and other people have done it. And
what's an average client look like, or regular client?
A regular client either has a business or some investable assets. Mm-hmm. So to be honest, if they've got a financial advisor and they're advising on assets, not just insurance, they're probably a good client for us.
Yep.
And
what type of work?
Well, we'd usually do. Usually, they need a estate planning, so that'd be wills, testamentary trusts, power of attorney, enduring guardian. Look at their superannuation, nominations. We talk about asset protection, so it might be, so you own this property, you can transfer half of it to your wife, or de facto spouse, tax free. They kind of go, oh yeah, that might be a good idea, given that I want to have a business in the future, or I'm hoping to get promoted to a partner or whatever.
And how often would you see a client? Once every 5 years, once every year, once every 10 years? What's
look? Probably on average once every 5 years.
Once every 5 years.
Yeah, but I always make a point at the end of it and say, listen, you don't need to come and see me now, but you're, Ray or Clayton or whoever it is at the annual meeting with you will realise that the moving parts are such that maybe we need to revisit the estate structure. What I say to people is I like to give them some documents that will last 15, 20 years, so that it's only significant changes would require a redraft. So yeah.
I think one of the things that I especially with Donal, but I think good lawyers do, they don't kind of accept orders. So send through a referral to get an estate plan done. It's not like, okay, well, this is the fee and this is what it is, and it's, you know, box standard. It's kind of like, all right, well, you sit down and Donald will go through a fact-find process, ask questions that no one kind of really thought about through different sort of experiences, and then sort of engineer a bespoke type of proposal off the back of that. But I think it really bodes well for when I've done it in the past on myself, and I'm sure for other advisors, when you kind of introduce someone into the mix who actually brings a different perspective and different ideas, like that, the value that comes through, that's, you know, very material in my experience.
Very good. Well, mate, I'm sure my fiance will be asking for your details within the week. And
well, if you're my client, I'll tell her that sorry I can't act for her. But,
smart, diplomatic as well, mate. Thank you very much for coming on.
Pleasure. Thanks very much, guys.
Thanks,
Cheers.
Thank you.